Hello, my name is Steve Kessler and welcome to today's Transportation Industry Best Practices webinar sponsored by Vertical Alliance Group and the Infinity Workforce System. Today's topic is what to do before and after OSHA knocks, an interactive look at the legal aspects of OSHA and citation defense. Before we get started, I'd like to go over a few items so you know how to participate in today's event. You're listening using your computer speaker system by default. If you would prefer to join over the phone, just select telephone in the audio pane and the dial-in information will be displayed. You will have an opportunity to submit text questions to today's presenter by typing your questions into the chat pane on the control panel. You may send your questions at any time. We'll collect these and address them during the session. Before we get started, I would like to extend a special welcome to those of you on the webinar today who are current users of the Infinity Workforce System. If you're joining us as a guest today and do not currently use the Infinity Workforce System at your company for online training, I would like to extend an invitation to you to join us at one of our upcoming Engage evaluation programs, where you will spend 2 days learning the latest trends in training your transportation fleets. This is a 2-day event that provides you with an in-depth training on how to overcome the challenges of training your workforce. You will learn how to become more profitable with less headaches, risks, and stress, and the event is provided at no cost to qualifying participants. Some highlights of the event would be we typically have an industry attorney speak to focus on making sure your company is prepared before, during, and after a catastrophic event. You'll learn how to create custom content easily and affordable that will allow you to actually create a piece of custom training on distracted driving while you attend the program. We'll also give you a complete background look at the Infinity Workforce System to show you how it works and all the features and functionality. And also you will be able to earn some professional development credits. If you're a certified director of safety, there are 2 NATME recertification points for attending. And if you're in the human resources world, HR directors will receive 8 professional development credits toward the SHRM certification. So if you'd like more information on how to get a free ticket to an Engage evaluation program, simply type Engage into the chat box and we'll contact you with more information. Additionally, you'll receive an email by the end of today's program with an invitation to attend. So now I'd like to introduce you to today's speaker. Travis Vance is a partner in the Fisher Phillips Law Firm's Charlotte office. He has tried matters across several industries and various subject matters, including employment litigation, business disputes, and matters prosecuted by the Mine Safety and Health Administration and Occupational Safety and Health Administration. He uses unique or outside the box approaches to counsel employers and owners on all aspects of employment law and the development of preventative policies and procedures to avoid employment and workplace safety related claims. Travis handles litigation in both federal and state courts, as well as claims pending with the state and federal agencies, including EEOC, MSHA, OSHA, and the U.S. Department of Labor. So without further delay, Travis, we're going to turn the program over to you.
Okay, well, good morning, everybody. I hope you're doing well. And Steve was going to switch it over to my screen here. Hopefully everybody can see it. Steve, if you could let me know when that's done.
I've just clicked on the change preventer to Travis.
Okay.
Okay, it should come in just a second now.
Okay, so we should be good to go. Well, good morning, everybody. I certainly appreciate everybody attending the webinar this morning. I hope you are all having a good summer. It's winding up. Summer here is starting to cool down a little bit here in the Carolinas. But today we're going to talk about OSHA inspections and citation defense. And I always tell folks that when I'm live in person, I know you don't want to listen to an attorney talk for 45 minutes to an hour. So what I like to do with all my presentations is try to make it interactive So you've got a chat function on the panel there for the webinar, and I'm going to ask a lot of questions today, so I hope that you guys will respond and keep this interactive. And I always tell people, you know, it might be a boring morning for you to listen to an attorney, but I'll try not to make it boring at all. I always tell people, before you give lawyers too much of a hard time, just remember that 98% of attorneys give the other 2% a bad name. So let's get started with my favorite quote of all time. I always like to start my presentations with this quote because I think it's very applicable to the practice of law. And it's not the critic who counts. So I say that because it's not the critic who counts. It's not the lawyer who counts. The lawyer that comes in and says, why did you drug test that employer? Why did you let OSHA do that? Or why did you give OSHA those documents? Rather, it's those who at the best know in the end the triumph of high achievement, and who at the worst, if he or she fails, at least fails while daring greatly, so that your place shall never be with those cold and timid souls who know that neither victory nor defeat. I always say that because, ladies and gentlemen, on the call, you are the men and the women in the arena. You're the ones out there in the field making the decisions when OSHA's across the table asking you for documents, asking you for interviews. And it's not my job to judge how you do your job in the arena. So we'll keep going back to that theme, but I think that applies not only to OSHA inspections and litigation, but just life in general. That's why it's one of my favorite quotes. So let's go to the first question. I told you it would be interactive, so just use your chat function there and tell me who said that quote that I mentioned there. Is anybody chiming in here? Let's see what kind of quotes we get there.
In the question pane, somebody put B, we got C, we got Roosevelt.
Okay. So a lot of people saying Roosevelt. So when I do this, I get a lot of people that say Teddy and a lot of people that say Winston. And it was actually in 1910 or 1911. It was a speech given by Teddy Roosevelt in Paris, France. It was part of a bigger speech, but that part of the speech is called The Man in the Arena. It's funny because I give this presentation a lot and I always get a lot of Teddys and get a lot of Winstons, but nobody has ever seriously said Bill Clinton. So let's go to the next. Let's go to the first case study for today's presentation. We're going to have two case studies. In the first case study, we're going to go back in time a little bit to November of 2015. And then your facility in Philadelphia got cited by OSHA for a serious violation of a fall protection standard and a serious violation of a PPE, personal protective equipment standard. And both of the citations at the time carried the maximum proposed penalty of $7,000. So that's what we know about the case study. And here you can see the cards laid out there. We're going to go to the poker table, to the informal conference with OSHA. And that informal conference is something that you get to do right after you receive the citations to see if you can get them worked out. So here's what OSHA is going to offer us at the informal. They're going to reduce the PPE violation to other than serious and $3,500, and they'll reduce the fall protection violation to other than serious and $0. So serious means it could cause a serious injury or death. Other than serious means basically it could not do that, and it would be reflected on your record as other than serious versus serious. So the question for you guys on the call is, do you accept OSHA's deal? You start off with $14,000 in serious and 2 serious citations, and now you got $3,500 and 2 other than serious. So Steve, what are we getting? The responses are not coming through to me, but what are you guys getting on that? Is there a lot of yeses, a lot of nos? All right. Well, we're going to take a yes on that. We get a lot of yeses, a lot of nos, but I always tell people that we have to take a yes because otherwise we wouldn't be able to do the second part of the webinar, which is the second case study. So we're going to take a yes on that, and we're going to get to our second case study. So it's the second part of the second case study in this webinar is that it's 3 years later after that first citation in Philadelphia. It's August the 15th, 2018. and you just learned that there was an accident involving a forklift that happened the day before, August the 14th at 2:00 p.m. The employee involved in the accident suffered an injury, drove himself to the hospital, and was admitted overnight. Now, neither the injured employee nor the two employee witnesses told you guys, anybody on the call, members of management, about the accident. Okay? So that's our second case study. We've got several questions we're going to go over first. So the first one is, can you drug test the employee? And we get a lot of split on this. A lot of people say, yes, you can do it. No, you can't do it. And the reason why a lot of people say yes is because a lot of employers have a program that says that if there's an accident that's reported, or if you're involved in an accident, you get drug tested. A lot of people have that policy, had that policy for a long time. Well, as of December 1st, 2016, OSHA says that if you have an accident, a drug testing policy that says that everybody that reports an accident, or everybody that's involved in an accident, whether it's a bee sting or driving the forklift off the dock bay, then you're going to be drug tested because there was an accident, and that's an illegal drug testing policy. Now, however, before you get too concerned, just remember there are a couple of exceptions here. One, if you're in a state, what I call a Louisiana state, there's other states like that, but a state like Louisiana says that you can drug test everybody that receives or applies for workers' comp benefits. If you're in one of those states, you can continue to drug test after every accident. The other exception is what I call a Virginia state. There are several states, Virginia, South Carolina, or a couple, where if you get a discount on your workers' comp premium because you have a drug-free workplace program that you follow pursuant to state law, and you get a discount on your workers' comp program, and it requires you to drug test everybody that's in an accident, you can continue to do that. So if you're in one of those two states, you can continue to do it. OSHA does not trump state workers' comp law. You can also still drug test after an accident as long as you have a reasonable suspicion or reasonable belief that drugs or alcohol impairment led to the accident. So it's real simple. If Johnny walks across the parking lot on his way into work and he's slurring his speech, he smells like alcohol, you're going to drug test him. That has nothing to do with an accident, but you're going to drug test him because of your reasonable suspicion drug testing policy. Just take the same analysis and apply it post-accident. Just give me a memo to the file, something in the file that says we drug tested Johnny, not because he reported an accident, but because his behavior of driving the forklift off the dock bay is inconsistent with sobriety. So that's all you have to do. It's real simple. If you need language, I've got language that I will send to you for free. Everybody on the call, if you email me at any point today, during the webinar afterwards at tvance@fisherphillips.com, T as in Travis, V as in Victor, ANCE@fisherphillips.com. I'll send you a lot of different things, including the reasonable suspicion, some articles that I've written about the topic, and obviously that's going to be all for free. So the second question is, can you discipline the employees for not notifying management of the accident? So here was an accident yesterday involving a forklift, drove himself to the hospital. Nobody ever told you guys about the accident. So a lot of employers are going to say, yes, we're going to discipline those employees because our policy says that everybody, that as soon as you find out about an accident, you have to report that immediately to management. Well, OSHA, again, December the 1st, 2016, said that you have to give, if you're going to discipline employees, you have to give them a reasonable time to report an accident or injury. And the reason why is because it said if you're in the back of an ambulance or you're at the hospital, you can't report that to your employer. Our firm actually handled the first case where OSHA came up with that reasonable time frame, and they said it was 8 hours or until the end of the shift. Okay, you can still have the immediate language in there, but if you discipline somebody, which means fire them or adjust their salary or dock their pay, then you could be looking at a whistleblower claim or potential OSHA citation, and we'll talk about that later. So it's real easy. Just take the immediate language out, change it over to the 8 hours until the end of the shift, or a reasonable time. Generically would be enough as well. So the third question is, do you call OSHA? So we've got an accident here involving a forklift. Gentleman drove himself to the hospital and he was admitted overnight. And of course, January 1st, 2015, OSHA changed its rules to say not only do you have to report a fatality within 8 hours, which has been the case for a long time, but you also have to report starting January 1st, 2015, an inpatient hospitalization, an amputation, and a loss of an eye, which literally means eyeball on your desk, not loss of vision. You have to report those three things within 24 hours as well. Now, if you're in a state plan state where the state government enforces OSHA, like a Kentucky or North Carolina or South Carolina, there could be different time periods for some of those. For instance, Kentucky has, if it's less than 3 hospitalizations, you have 72 hours. So if you're one of those states, just check the local rules with respect to the reporting requirements. And then the fourth question is, do you have a safety bonus program? And the reason why I bring that up is because the third part of OSHA's December 1st, 2016 rule related to safety bonus programs. OSHA doesn't want you to have a bonus program that disincentivizes employees from reporting accidents and injuries because they're afraid they won't get a bonus or they won't get some sort of award, whether it's, lunch every quarter or everybody gets their name in a hat to win a truck at the end of the year if there's no recordables. And the reason for that, I think, is straightforward. If you're not going to get a bonus, you're not going to get some of an award for the amount of recordable injuries, then you are not going to report it. And then if everybody gets the same incentive, if there's no recordables for the whole company, then you're going to tell your buddies at work to not report it. So that's why OSHA has made it clear in the regulations now that if they believe that an employee would not report an injury because they're afraid they wouldn't get a bonus or an award, then that bonus program is improper under OSHA regulations, okay? So that's the third part of what I call the three-legged stool for the December 1st, 2016 rule changes. That's the drug testing, the reporting, and the safety program. They're all anti-retaliation oriented. I wrote an article about those three. It was called OSHA Drugs and Rock and Roll. You may have seen it in a national safety publication. But OSHA, lawyers in general are boring. I know that's hard to believe, but I like to write about things that are safety related that get people's attention. So what I did was I made each part of that rule a different song and then turned it into a soundtrack. So that's where OSHA Drugs and Rock and Roll came from. And so, for instance, you got to give employees 8 hours to report the accident or injury. So I used my favorite Guns N' Roses song, Patience, as the song that reminds everybody that we have to give them 8 hours. So again, if you email me, I'd be glad to send that as part of the package that you get as well.
Hey, so Travis.
Yes, sir.
There's a question that popped up. Do you want to take it now or do you want to wait till the end?
Yeah, well, I can take a question right now.
Here's a question from Jim. It says, based on the state reporting requirements mentioned, does this apply to where the event occurs or where the employee's home domicile location is?
I would always start off with where it occurs because you want to make sure it is reported. So I would start off with where the state it occurred because that is the agency that's actually going to respond to the incident. So I'd always start there.
Okay. One other quick question from Sharon. She's asking, do you have a sample bonus program?
I can send over some. That's a good point. On the bonus program, what you do is you go from a lagging indicator. So a lagging indicator is a recorded an accident or how many recordables you have. Those are things that have already happened and you can't do anything about them from a safety standpoint going backwards. But you switch those over to leading indicators. So in other words, you make your bonus program based on reporting a near miss or serving on a safety committee or having good audit reports for PPE and lockout, tagout. Those are all things that prevent injuries in the future. So those are leading indicators. So what we do is we just change lagging indicators over to leading indicators. So if they would like to email me, I'll be glad to send them a list of the items they can put in their bonus program that would be compliant.
Great. Thanks, Travis.
Yeah. All right. So the fifth question is, do you take statements from the injured employee and witness? And of course, if everybody has an accident, if you have an accident at your workplace, you're probably going to take injured employee and witness statements. That's pretty par for the course. Now, how you do that is the more difficult question. a lot of people say, well, I just want to hand them a piece of paper and have them write down what they saw. Well, again, man in the arena, not trying to judge, but what I've seen is the best practice is that you interview the employee, you summarize what they say, you give it to them, make sure it's completely accurate, and then you have them sign it. If they start writing it, the problem is that they may put things in there that are not relevant or not helpful to the situation. So my example is I had a case one time where a guy drove across an intersection and hit a guy in an 18-wheeler. So we had the 18-wheeler hit a guy at a red light. They hand the driver a piece of paper and say, "Give me your statement." Well, his first sentence was, "As I approached the dangerous intersection." Okay, that's just not necessary, and it's not relevant, and it's his opinion as to whether or not it's a dangerous intersection. So that's not the kind of stuff you want to have in there. It's the same thing with the photographs. After an accident, people take photographs. No reason to put blood and guts in the photographs. That's not helpful. Okay, we're just creating evidence for somebody else. So the sixth question is, do you call counsel, which is related? So this is not self-serving. I just wanted to point out what the point of having counsel involved is, what the major point is. If you have a major accident, absolutely a fatality, or if you have an amputation or hospitalization, the reason to get counsel involved is because once counsel is involved, the investigation is protected by attorney work product. So hopefully OSHA or a plaintiff's lawyer or some other agency will not be able to get a copy of that because it's protected by attorney work product. But if it's not led by an attorney, then you may not have that right. Okay. And then the seventh question is, do you have to electronically upload your OSHA 300 to OSHA's website? I bring that up because here recently OSHA started requiring establishments, which means a single facility, one brick and mortar facility with 250 or more employees, or if you have between 20 and 249 employees at a single establishment and you are in certain industries like construction, manufacturing, high hazard industries, you have to upload your 300A information to OSHA. It was July 1 this year. Next year it's going to be in March. They just changed the rule to not require those with 250 or more at a single establishment to upload the 300s and the 301s. But that was the only change that they made. So this requirement's actually here to stay. So if you have to report that, make sure either you go ahead and do it this year and also make sure that you're doing it going forward. Again, if you have any questions, you can email me. I'd be glad to talk to you about it. Okay, so we went over the drug testing policy, and just to reiterate, it can be still conducted if your state law allows. The accident or injury was likely caused by an impairment, as I mentioned, the reasonable suspicion. And if you also use a test that will determine if the impairment existed at the time of the accident. So in other words, it's good to take them to a medical clinic or a actual medical facility to do the drug testing so they can actually do a comprehensive, sophisticated test to make sure that the impairment existed at the time of the accident. And I always joke and say it's not a good time to use the breathalyzer in your desk drawer that you had to see if you could drive while you were in college, okay? So the next part is the reporting. Just to reiterate that, OSHA says you have to give them a reasonable time, no later than the end of the shift or 8 hours.
Travis, another question real quick.
Okay.
Somebody asked, do you have to electronically report even if there have been no injuries or events?
You would just go on. The 300A is a summary of how many accidents and injuries, how many injuries and illnesses there's been at your facility. So that information would be a 0. So you would just go online and put in the 0 information.
Great, thanks.
Okay. So the question is, do you call OSHA about the hospitalization or do you report it online? So we talked about that. We do have to call OSHA because it's a hospitalization, and as of January 1, 2015, we're obligated to do that within 24 hours. So the question is, do you call OSHA or do you report it online? The feds will let you report it online, and so do most state plans. So I used to be of the mindset that we should just call them at 4:45 p.m., leave a message. Obviously, they're probably not going to come out that day as long as they're within the 8 or 24-hour limit, and then they'll come out the next day. But lately, I've been more geared towards reporting it online because I'm convinced that we're obviously going to be honest with OSHA, But if we're honest with OSHA and generic with the description of the accident, as opposed, so in other words, he is, instead of saying he had 7 surgeries in 3 days, you can say he's hospitalized due to an injury. So we're honest about it, but we're bland and generic about it. And that way, OSHA does not get the emotional attachment of, or the emotional excitement from the injury, so that when they're going through it, they see it as a hospitalization or a laceration, as opposed to something that could be much more devastating if you read it. So in other words, a lot of employers will want to be very detailed and descriptive, but what they don't understand is when they're doing that, they're actually inviting OSHA to come out when they may not do it another time. So if you do that, if you're honest but bland, then you'll get an opportunity more times than not to do a written response as to what happened, as opposed to having OSHA actually show up, which is obviously a better thing to do. So I'm of the mindset of reporting it online as long as we can be generic in description, because a phone call, obviously, they're going to be asking you a bunch of questions, and everybody on this call is a manager or supervisor. And anytime you talk to OSHA, you can bind the company. And if you're aware of a hazard or admit to a hazard, then they've already proven the most difficult part of proving an OSHA citation, which is knowledge on behalf of the company of a hazard. All right, so let's go back to the case study. And after we call OSHA, so we report it to OSHA, a compliance safety and health officer is at the door on August 5th, 2018. And let's say we're at your Atlanta facility, and OSHA's there, they're knocking on the door, and they want to do an inspection. They're mandating to conduct an inspection. So the question is, do you have to allow them to do this? And some people will say yes, and some people will say no on this. But I always tell people that these are all trick questions, and the reason why is because a lawyer is asking them. But with respect to this question, the technical answer is no. You don't have to let them in. It's a Fourth Amendment search. It's just like if they showed up at your house. If they don't have a warrant, they can't get in your house. If they don't have a warrant, they can't get in your facility, okay? However, that's not the best advice. It's not what I counsel employers 99% of the time. And the reason why is because OSHA says if you make them go get a warrant, they won't use it against you. However, studies show that you'll get cited about 6 more items with a warrant than without a warrant. Okay, so we're all human beings, and they will be frustrated if they do that. The best approach is to allow them to come in, put them in a conference room, figure why they're there, figure out what the scope of the inspection is. It's the forklift accident, it's the amputation, it's whatever they're there for. Then we stick them to that scope, okay? There's only 2 ways OSHA gets on your site. 1, with a warrant, and that's when a judge tells them what the scope is, or 2, with your consent, and that's when you tell them what the scope is, okay? So that's why it's a better practice to allow them to come in, figure out why they're there, and then keep them to that scope. Again, man the arena, much easier said than done, but it can be done, and it is the law, as we'll get ready. I'll mention here in just a minute. So very few employers require a warrant, could be required in very unusual circumstances. There for a while, 5 years ago, OSHA thought they could bring a union steward to any plant in the country, including non-union shops. They said they're not doing that anymore, but that would be a situation where you'd make them go get a warrant. So the opening conference, that's when the compliance officer comes in. We're going to park them in the conference room, and then we're going to set the ground rules for the inspection. What's the scope? Give me a copy of the complaint. It will be redacted, but it'll say what the complaint is, okay? Make sure you don't volunteer any information. Just remember, you're always on the record. You're a manager, you're a supervisor, everything you say will be used against the company, could be used against you. Just depends on what happened. Make sure you treat them with courtesy and respect. You know, I always tell people my mother-in-law was the head of OSHA until she was the head of OSHA of South Carolina until July 1, 2018. So I had a greater burden to make sure I treated everybody with respect, because obviously you want to be very professional, and you also don't want them to tell your mother-in-law on you. So you notify corporate officials and counsel, make sure they know OSHA's there. If you have a proprietary process or some other trade secret, make sure you tell OSHA that so that they don't photograph it and then hand it out to the public in response to a Freedom of Information Act. That needs to be put in writing. And then if you have a contractor or vendor that works on site, make sure you coordinate with them that OSHA is there, because they'll appreciate it, because either they will participate in the inspection or they're going to get out of Dodge because OSHA is there. But the opening conference, probably the most important part of an OSHA inspection. So throughout the inspection, make sure you remember it's your site, it's your house. You have rights for the inspection to be conducted at a reasonable time and in a reasonable manner. And OSHA has 6 months to complete the inspection. I say that not because it's a short period of time. I say that because it's a long period of time. And that's because OSHA will show up on day 1, and by the end of day 2, they want you to have given them everything they're asking for. But just remember, we'll talk about what you have to give them in a certain period of time, but they have that 6 months. Now, honestly, they really only have about 5 months, because they have to have about a month to figure out what the citations are, but don't let them rush you into a 24 or 48-hour inspection. So the opening conference, talked about this. Make sure you know what the purpose and the scope of the inspection is. And then if OSHA, here's another question for you guys. So OSHA comes in and they say, we're here for the forklift accident, but we're going to expand it to include your ladders program, your lockout tagout program, and your emergency action plan. How would you guys respond to that? Or the compliance officer says, since you're on an emphasis program list, which means that your industry has a high DART rate or a high injury rate, we're going to look at the whole plant. We're going to go comprehensive wall to wall. And I've got a case up there, the Marjack poultry case that was out of Georgia. That was the issue. So OSHA showed up at Marjack. They had a complaint, and they said, you guys are in the poultry industry. You're on an emphasis program list, so we're going to look at the whole place while we're here. And Marjack said, no, you're not. You're not going to do it. And that case is still on appeal. Parts of it are. But Marjack has prevailed at every level, because the judge said that the compliance officer cannot unilaterally expand the scope of the inspection. So he can't go from a complaint to a wall-to-wall on his own. The only way they could go wall-to-wall is if Marjack was next on the list for the emphasis program inspection. They can't skip down the list just because they're there out of convenience. And OSHA was doing this a lot. The last 2 to 3 years, they were expanding scopes of inspection. And the reason why is, as I mentioned, in January 1 of 2015, they made the amputation reporting requirement, which probably changed OSHA more than anything else that I've seen in the last 10 years, because there are so many amputations, there are so many inpatient hospitalizations. So what was happening is their resources were all spent on inpatient hospitalizations and on amputations. They didn't have time for an emphasis program inspection wall to wall. So they thought we'd kill 2 birds with 1 stone and do them at the same time. Well, thankfully, the Marjack case started setting the tone on this. And then I had a case in eastern North Carolina. Very similarly, OSHA shows up, 6-part complaint, wanted to look at those items, and then said 2 weeks later, by the way, we're going to look at the whole plant because you're on an emphasis program. Well, the client objected to that, but OSHA said, we don't care, we're going to do it anyway. So they did the wall-to-wall, and at the end, by that point, I'd become involved. OSHA shows up for the closing conference at the end of the inspection and says, on the complaint items, we didn't get any penalties, but on the expansion, we got $35,000. Okay? So I wrote a letter to OSHA. I laid out the Marjack case, explained to them that they couldn't go wall-to-wall under these circumstances. And about 2 days later, got a letter or a call back from OSHA. It said, you know what, we read your letter. We agree with you, and they vacated all $35,000. So at least in the Southeast, if they show up on a complaint or they show up on a referral, an amputation referral where you called OSHA, don't let them expand the scope of the inspection. And I always tell people, we're not trying to hide anything with respect to limiting the scope. We're just asserting our rights, and it's a drain on your resources financially, from a productivity standpoint, if OSHA is looking at the whole facility, spending several days out there versus just going in and going out to get the inspection over with. So just keep that in mind.
Travis, question came from Sharon asking, what courses would you recommend to complete or take to become more familiar with regulations and requirements?
Well, the easiest ones to start off with are the OSHA 10 and OSHA 30 courses. And if you haven't taken those, I would recommend you do that. Now, keep in mind that OSHA 10 and OSHA 30 they only go over the substantive nuts and bolts of OSHA regulations. Unfortunately, they don't they don't go over inspections or what your rights are during inspection. So I've actually started offering to some of the trade associations to do what I call an OSHA 12, which is the OSHA 10-hour plus my 2-hour course on what to do when OSHA shows up. But if you're looking for just more information about regs, I would definitely recommend the OSHA 10 and OSHA 30. The National Health and Safety Council does a great job, and they're pretty cheap. They're a publicly funded organization.
Great, Travis. Another question just popped in relative to what you were just speaking about. This came from Mark. He says, on an amputation in the field, OSHA in New Jersey has expanded their scope wall to wall without notification. We can fight this later, question mark.
Yes, I mean, just don't waive your 15 days to contest the citations. And I've got cases in New Jersey right now. I know how aggressive they are. So again, if you have any questions, please email me. But if they've expanded it improperly, then there's a good chance you can get the citations vacated. So it's better to act earlier than to wait and perhaps waive it.
Great. He responded back, excellent, thank you.
Okay, so during the opening conference, the compliance officer, he's going to ask you for documents, or she's going to ask you for documents. So here in our case study, the compliance officer asked for your entire lockout tagout program, your PPE purchase invoices for the last 3 years, your OSHA 300 and 300A forms for the last 3 years, your safety data sheets, and your forklift training records for the last 2 years. So the question is, do you have to give as a compliance officer these documents? Well, keep in mind, there's only 2 types of documents that you have to give OSHA within a certain period of time, okay? Every case, if they ask for the 300 to 300As and the 301s, you have to give those to OSHA within 4 hours. That is the law, and you will be cited for it if you don't, okay? So always keep your 300 logs up to date, because you never know when OSHA is going to show up. The only other document that you have to give immediately, if it's within the scope, is the safety data sheets. Here, that's probably not within the scope unless there was a chemical issue with the forklift. However, the safety data sheets have to be given immediately because they have to be readily accessible. So you have to give them to them immediately if they ask for it, because if you don't give it to them immediately, then they're not readily accessible. You'll be cited for it. Everything else, we are going to take a list, okay? We're going to take a list of what they want, and we'll get back to them, because we have to figure out first if it's within the scope, if we've got any protections that are afforded to the documents, attorney-client privilege, work product, anything like that, and then we'll get back to them later in a comprehensive response. Because 1, they've got 6 months to do the inspection, don't let them rush you, and 2, if we don't give it to them in a comprehensive response and we start piecemealing that, if we piecemeal the lockout tagout program, we piecemeal the ammonia safety PSM program, don't assume that OSHA is smart enough to figure out how to put all those together. Because I tried a case in Texas for 6 days because my client piecemealed their response to OSHA, and we got cited for $100,000 in penalties for not having programs we had provided to them because OSHA was not smart enough to put them together. Okay, so that's why it's important to do a comprehensive response, because OSHA is busy. They're not going to have time to go back and piece all those together. All right, so let's talk about the walk around. That's after the opening conference. You talk about the documents. Then OSHA says, all right, let's go take a look. This is my favorite part. You know, I always tell people I'm just a redneck from Bristol, Tennessee. I took 4 bar exams, not the same bar exam, 4 different bar exams. But I found OSHA and MSHA litigation. I love it. This is my favorite part of it. It's very blue collar. But where's the compliance officer going to go? Okay, so he could be there. I've had OSHA on site for 28 days. He could be there for 28 minutes. Okay, you've got the absolute right to accompany the compliance, safety, and health officer at all times. Please don't let them go out there by themselves. I've heard horror stories of, OSHA's on the back lot again. That should never happen. All right. So the important thing is, where should they visit? Always ask the question, what should we do with the forklift in this case? Well, it's kind of a trick question, but if you get creative, we can put that forklift out in the parking lot. Okay, as long as it's protected from the weather and we don't tamper with it. And why is that? When OSHA shows up, we have the opening conference in the front conference room. Then we go outside. We go to the parking lot. We go over to the forklift. That's the scope of the inspection. Okay, And the reason why is because if you start taking them down through the warehouse all the way back to the forklift and the dock bay, everything that they see on the way there is fair game. It's called the plain view doctrine. Just like I say, if they showed up at your house and you had an illegal weapon in the back bedroom and they were looking for an illegal weapon and you took them through the kitchen, and on the way through the kitchen, you know, because you'd been hanging out with your buddies from college the night before, there was some marijuana on the table, they're going to bust you for that marijuana just like they're going to bust you for that illegal weapon in the back bedroom. So it's the same concept. Everything that they see on the way there is fair game, and they've got an obligation to cite you for it if it's a hazard to employees. So don't be taking them through the warehouse and showing them all the different things. Take them to the back door, straight in, straight out. Take them to the parking lot where the forklift, straight in, straight out. That's the scope of the inspection. And just remember, it's not a time to brag. Don't be talking about projects you have going on. I had a client that bragged about a project they had going on the rooftop and took the OSHA inspector up there. Well, OSHA went up there and cited them for 3 items because there were violations up there. But if they didn't brag about it and they didn't take them up there, OSHA would have never seen that project. So not a time to brag. After the walking part, the opening, the walkthrough is over, OSHA's going to send you emails. They're going to keep asking for documents. These are 3, this is actually 3 emails from OSHA that I've received in cases before. The first one is, please provide the name of all temporary workers. Well, this was a case involving a amputation on a press machine. Our response to that, there were no temporary workers working on the press machine. Why? Outside the scope. Never ask another question about temporary workers. Second one, please provide name of all contractors working on site when I was present with the emoji smiley face in the original. So I just said, here's the contractor that works there every day. Anybody else, we wouldn't be able to tell you who was there at the particular time because, frankly, we're not going to do OSHA's job for them. And then the last question, or last one, my favorite of all time, if you don't provide the lockout tagout program by today at 5, I will note that it does not exist. Well, this was a situation where the client had not reported an amputation because they didn't know they didn't have to. They had to. They saw one of our articles, and it was 2 weeks later, and they're like, oops, I guess we should have reported that. So they called us. So we got ready for the OSHA inspection, and then we called them. So we called them. They showed up, and the client called and said, oh, this guy's so nice. I don't think I need your help anymore, Travis. I said, okay, that's fine. And then on the second day, he sends me this email and calls and says, I think I need your help on this. So I called the OSHA inspector. After I said, hey, I look forward to working with you, what was the first thing I told him? Oh, you don't have to have that lockout tagout program today by 5, right? Because you still got 6 months to do it. Yeah, that's fine. No, you don't worry about it. We got it to him 2 days later. No violations, no citations whatsoever with respect to the lockout tagout, and he never asked another word about it. And the reason why is because we wanted to make sure it was a comprehensive response because we had some concerns about our lockout tagout program, so we wanted to make sure it was robust and comprehensive before we gave it to him, and it was no problem. So going back to the inspection, let's say you're walking the inspector around and you go outside to a 3-story warehouse and you see 3 employees of a subcontractor up about 25 feet above the ground, and they're installing equipment without fall protection. So the compliance officer takes a video of this, and then he asks you, the manager, whether you think they should have fall protection. So just a few questions about that. Do you have to allow them to take the compliance officer take photos or videos? Well, the answer to every question going forward is going to be, first and foremost, is it within the scope of the inspection? Now, I know, man in the arena, you can't be out there tackling compliance officers if they're photoing things. You don't want them to. So here's how you get around that. During the opening conference, you tell them, if you're going to take a photo or video, I want you to tell me. And then you take a photo and video at the same time, okay? That way it's documented. We know exactly what they're doing. If they start taking photos or videos of other things without telling you, first of all, tell them to stop doing that. It's outside the scope. And then ask them what they're photoing or videoing. And the reason why is because if they see something else while they're out there and you can pick up on it during the inspection, then it might give us a heads up as to what they're looking for with respect to citations, and we can go ahead and start establishing our defenses, okay? And I want you to take a photo and video of everything they take a photo and video of. In fact, if you can get them taking the photo or video, that's even better because I want to know exactly what they are looking at. And then they might start asking you to do a sample of, let's say you're welding on stainless steel and they want to know if there's a hex chrome exposure, or let's say they want to do a noise monitoring test. If they want to do any of that, we need to be doing it side by side. And again, they're not going to do it that day or that afternoon. They're going to do it when we have an IH, an industrial hygienist, there available to do it at the same time. Again, they've got 6 months to do the inspection, and if we don't get the same testing, we will never be able to duplicate the conditions. It's very important. So you're out there and you're talking where the work's being done, and then here comes a supervisor and an hourly worker on forklifts driving by, and they're talking about whether or not those employees should have fall protection. So the compliance officer hears this, and of course he wants to take their interviews or do their interviews. So the question is, do you have to let them do that? Well, again, it's within the scope. They can talk to employees who work on that machine where the amputation occurred. They can talk to forklift operators, but they don't need to talk to everybody just because they're employees. It has to be within the scope. More importantly, can you sit in on the interviews? Now, you can sit in on an interview if they're a manager or supervisor. Very important. Manager or supervisor buying the company, you have the right to be in there. Very important. If it's an hourly worker, then it's up to the hourly worker. If they want a confidential interview with the OSHA inspector, that's their right. Okay. But before the hourly person goes in there, make sure that you and/or OSHA both tell the hourly worker that they can turn down the interview if they want to. They could be subpoenaed. They can have somebody in there if they want to. They have to tell the truth, and that the company is not going to retaliate against them for participating in the inspection. Okay. Should you sign a witness statement? You're not, as a manager or supervisor, you are not obligated to sign a witness statement, okay? Just keep that in mind. If you do decide to sign it, don't ever sign it on the day of the interview, because I want you to have a cooling off period where you can take a look at it, make sure it's 100% accurate, because if it's not, then we're going to have to deal with it later on in the hearing, and they're going to have an admission against the company. And then, can the compliance officer inspect the forklifts? It's a good question. They were driving by during the inspection. He saw that. That's probably going to be plain view, putting it within the scope. So the lesson here is, during an OSHA inspection, don't have any employees operating industrial trucks or heavy equipment, okay? Don't be doing that. It's a good time to do housekeeping. Don't be having folks going around on forklifts during an OSHA inspection. That always draws their attention. And if they see it, like I said, as they're walking around, it could come within the scope, even if the original complaint or referral had nothing to do with the forklift.
Travis, a couple of questions have popped in. Sharon wants to know, do you ask them to return once we have testing equipment or personnel available, basically schedule the sample tests?
That's correct. Absolutely. So what you do is you can do the scheduling, you can do the sampling if it's within the scope, but we're going to do it at a later time, mutually convenient, when we can have an industrial hygienist at the same time. And if they do it if they do it even though you tell them not to, then we're going to tell them they can't use that against us. And specifically, the OSHA Act, which is the law, says that any point during inspection, if they're doing something that you object to, you tell them, and they have to cease doing that and go talk to their supervisor. So absolutely, it should be scheduled at a later point.
Okay, another follow-up by Sharon. Please repeat the 3 options for interviews for hourly employees.
The hourly employees, they obviously have to tell the truth. They can turn down the interview with OSHA if they want to, but OSHA could send a subpoena for them. Just keep that in mind. They can have a confidential interview with OSHA alone, or they can have anybody in there they want to. They could have a manager in there. They could have their cousin in there. They could have their own lawyer in there. And then obviously tell the employees that they are not going to be retaliated against if they participate in the OSHA inspection. You don't want to retaliate against your employees that participate in an OSHA inspection, because then you're looking at a potential OSHA violation and a whistleblower claim, a retaliation claim.
Okay. Another question from Gabriel wants to know if there are specific guidelines from OSHA for a fuel hauling company.
a fuel hauling company.
Yes.
Well, with respect to you guys, a lot of you guys are going to be DOT regulated. So when you're on the open road or interstate commerce, basically moving product, then DOT and other agencies would be have jurisdiction. OSHA would only kick in once they're docked and unloading and loading and things of that nature. But there are a lot of different OSHA regulations that could apply, like hazard communication, maybe process safety management. Just depends on what type of chemical it is, how much of it they have, and how they handle it.
Okay. And one last question from Sharon. Who's responsible if the majority of the workers are temporary employees and not employees of the company, but you, the company, do supervise their daily duties? Is the company responsible for training, documentation, etc., or is it up to the temporary agency to do this?
Okay, it's a good question. So if you have temporary workers on your job site, you need to treat them like your own employees. Make sure they've got the same training that your permanent employees have. Because what OSHA will do, they'll come in and they'll cite the staffing agency and they'll staff the host employer because they frankly don't care who's got the obligation. So I always say don't let anybody work on your site as a temporary worker without them having the same training as your full-time employees. And if you're supervising even a temporary worker, you have the obligation to report their injuries and illnesses on the 300 log. So the temporary workers go on your 300 log and not the staffing agency. That's another distinction there that a lot of people don't realize.
Great.
And OSHA
Thanks.
actually just came out with some brand new directives reminding everybody that temporary workers should be treated just like their full-time employees. Okay.
Great. Thanks,
and I'll be glad to send those. If anybody wants to email me, glad to send those to you as well. So with respect to interviews, you want to have them on the production. You do not want them to be on the production floor, because if they're on the production floor, again, plain view doctrine, they can see things. They'll ask them about equipment. How do you do this? How do you do that? Got to put them in the conference room, okay? We talked about advising their employees of the rights. If you get the opportunity where OSHA says, just give me 5 hourly employees, that's like hitting a home run in an OSHA inspection. Everybody on the call knows that they've got an all-star team of hourly workers. They would want to talk to OSHA, and they've got a not all-star team of hourly workers. They don't want to talk to OSHA, okay? So if you get the opportunity, you give them the all-star team. Unless they specifically request certain employees, then you give them the best ones you've got, because that's a great opportunity to put your best foot forward in OSHA inspection. If you have employees that complain, grumble, always missing work, things like that, they're more likely going to make things up or not be truthful with OSHA about prospective safety issues.
Travis, quick question. Does OSHA have the right to approach and question customers?
Well, they can technically interview anybody that they want to, but my thought on that, on a customer, is that you don't want the customers to be out there in an area where OSHA is at the time, because it's not going to look good for you if OSHA is there in general. So I would try to keep the OSHA inspectors away from customers, but they could technically interview customers. I don't know exactly what customers will be able to give as far as pertinent information on safety programs, but they could technically interview them if they wanted to. And again, just remember, everybody and everything that they see is fair game doing an OSHA inspection.
Yeah, this actually is a recycling transfer station that's asking.
Yes, you might have contractors and things like that, or but basically they could interview the customers, but I don't know how relevant the information would be.
One last question: is it a good idea to require employees to sign training acknowledgement forms as proof of training?
Yes, and one of the things that with an OSHA inspection, there's a defense called employee misconduct, okay? And you don't like to throw employees under the bus. Sometimes employees do stupid things. But the only way you can win on an employee misconduct defense is that you have to have a training, you have to have a safety rule on point. You have to train and communicate that rule to your employees, which could be proven through the certification, the written certification. Then you have to audit to make sure that the rule is being, followed, and that you're making sure that folks are following the rule. And the last thing is you have to discipline employees who don't follow the rule. So just keep those things in mind. Very important on the front end in case something happens that you can't avoid, which is why the employee misconduct defense is available. So during the closing conference, that's when this guy comes back. That's when the inspection is over, and they are going to talk to you about what citations you're probably going to get, how to correct things, what abatement issues you may have. You can ask for photos and monitoring results. They may not give them to you. But the most important thing is just to listen to OSHA, take really good notes, and figure out where they're going with the inspection. They'll talk about how to contest the citation, what your appeal rights are, and what the next steps are, okay? So in this particular case, we get our citations. And we're going to get a citation for those subcontractor employees working without fall protection. And you say, that sounds crazy. Well, if you have employees on your site, even if they're subcontractor employees, you could be cited if you created the hazard or didn't do anything about the hazard and it was your job to do it. So in this particular case, if it was our obligation to give them fall protection, we could be cited for it. OSHA doesn't care about that on the front end. They're going to cite us and they're going to cite the subcontractor. Then it's up to us to convince them they should drop the citation. So we get a violation for fall protection, and they hit us for a repeat. Remember back at the beginning at that first case study at the Philadelphia facility when we took that other than serious and $0, where they're going to use that as the basis of a repeat violation, and they're going to hit us for $129,000. Well, you're going to say that's crazy. I'm going to show you on the screen. Here are the current maximum penalties for Fed OSHA as of January 2018. Starting in 2016, they bumped up substantially from the 1990 numbers, and now currently, and they're also being adjusted every year for inflation, so they're going to continue to go up. But as of right now, they're $12,934 for a serious and other than serious, and $129,000 for $336 for a willful and repeat. Now, you might say it's crazy, Travis. We had a $0 other than serious, and they turned it into a $129,000 repeat. Well, I say that because I had it happen to a client. They had a lockout tagout citation. They went to the informal, got it reduced to other than serious and $0, and then 3 years later, they got another citation in another federal OSHA state. So if you have a location in West Virginia and a location in Georgia or Florida, Texas, those citations can all be used again as repeats for future citations because the feds can go across state lines. In that case, the client got a $58,000 repeat in Georgia based on that $0 other than serious. This is the biggest fable, if you can write something down, the biggest fable about OSHA citations and OSHA litigation is that an other than serious citation cannot be used against a repeat. That is simply not true, okay? OSHA does not look at the classification for repeats. They look at the hazard. So if the hazard is similar for two citations, whether they're serious or other than serious, they can be used as a repeat. Now, another thing that OSHA just established was their policy has gone from using repeats up to 3 years to 5 years. So it used to be that if you had a citation within the last 3 years, you had the same hazard in another federal state, you could get a repeat. They just increased that a few years ago to 5 years. Well, a company in New England got a citation, a repeat based on a 4-year-old citation. They filed a lawsuit and said, well, OSHA can't do that. They improperly increased it from 3 to 5 years. Well, talk about biting off more than you can chew. OSHA actually came back and said not only can it be 5 years, it can be as long as they want because the 5 years is an internal policy. It's actually not the law. Haven't seen it happen, but OSHA could technically go as far back as they wanted to 1970 for the basis of a repeat because the law does not have any restriction against that. So we also get another citation for our drug testing policy for drug testing everybody that reports an accident for a serious citation of $12,934. The reason why I put that in there is because before December 1st, 2016, if you fired Johnny because he wouldn't if he wouldn't take a drug test, then you would get a whistleblower claim where you might have to pay back pay or reinstate Johnny. Well, now you can still get the whistleblower complaint, but you can also get the penalty. The reason why that's significant, because whistleblower complaints have to be filed within 30 days of the action taken by the employer. A citation can be issued up to 6 months. So it essentially extended the statute of limitations for OSHA. Just a few things here in closing to take into consideration before you pay an OSHA citation. This is probably the most important slide if you want to take a picture of it, is that if you think that the amount of an OSHA penalty is bad, well, then try losing $1 million contract because you have a bad safety record. There are companies out there like ISN Safety World where their job is to package safety records and sell it to their customers. So you may have a bad safety record because you have a lot of OSHA citations. They could have gotten your safety record from ISN Safety World, and you could have missed out on $1 million opportunities that you never knew existed because you've been taking those serious, or you've been taking those other than serious citations. So there's a lot more involved than just the amount of the penalties. Public perception. The only thing worse than having a fatality at your facility is a fatality where you paid the OSHA citation, and then it's going to be a press release, or it's going to be in the newspaper. Abatement costs. If you accept a citation, you not only have to pay the penalty, you also have to fix what the alleged hazard is, which should not only be costly, but also OSHA could make you do something that's infeasible. You may not be able to do your job anymore. So think about those costs. And then repeat and willful costs, we talked about that. Repeats, OSHA's policy is 3 to 5 years to increase the penalties on the second citation. Willful, no statute of limitations. They can go back as far as they want to. But if you get a citation, you accept it, and then you had a fatality for the same hazard 10 years later, they could go back and say, well, these guys knew that there was a hazard because there was no guard on that machine. They didn't do anything about it, and somebody got killed. So now we're going to step it up to a willful. So not only does the penalty go up, you can actually, as a supervisor, be criminally liable if somebody dies as a result of a willful citation. There was one in California recently where a gentleman was burned alive inside of an oven, and that resulted in criminal liability. So it does happen. They're very rare, but just something to think about. And then if you think OSHA is bad, try working with EPA, some of the other agencies that have additional penalties. And then keep in mind that if you have a third party on your job site and they die or they suffer an injury because of a hazard you created, then you can get the OSHA citation, and then it could be used as evidence of negligence in that third-party wrongful death claim or personal injury claim. If you pay that OSHA citation, then they could say, well, look, they were negligent because they paid the OSHA citation. And finally, if you're in a state like North Carolina, Ohio, Kentucky, they have laws that say that if there's an accident that results in an employee injury and the employee seeks workers' comp claim, then he can get a 10%, 30%, or 50% increase if they can show there was a violation of an OSHA violation. North Carolina's 10%, Kentucky's 30%, Ohio's up to 50%. So if you accept an OSHA citation, there was an accident in a workers' comp claim, then that claimant might get increased benefits because you pay the OSHA citation. Even if it's other than serious, that can happen. And the workers' comp, your workers' comp adjuster, your workers' comp policy may not cover that additional amount, so you may have to bring that out of your own pocket. So just keep those in mind. And then finally, obviously, safety is paramount. We all have the same mission. We have the same mission as OSHA with respect to keeping everybody safe. OSHA says that if you spend $1 on a safety program, you'll get $6 back. An occupational death is $910,000 if lost to your company. A lost work day is $28,000. And the indirect cost of a workers' comp claim is between 4.5 and 5 times the actual payout to the employee. What that means is increased premiums. Your EMR rating is probably going to go up. Your policies are going to be expensive, much more expensive for a long time. And obviously also productivity with respect to your workplace, because you're working on the OSHA citation and the workers' comp claim as opposed to doing your business. So I think we're right at the end, Steve. I've got a few minutes for questions if anybody has any questions. But again, please email me. I've got a copy of the article, OSHA Drugs and Rock and Roll, that I mentioned. I've got 2 documents that you can use to train your employees about OSHA inspections. It's basically everything we went over. It's just a document. It's a boilerplate document. You can put your logo on it, train your employees. It's good to have something in writing when you train them, and it just goes over what to do when OSHA shows up. And then I've got the reasonable suspicion language for drug testing. And finally, I've got a checklist that you can use to determine if somebody is under the influence of alcohol, and it's a form you can use to sign off with lines and everything as far as making sure that we're compliant with OSHA's anti-retaliation drug test rule. So I'll leave it up to questions, and if anybody ever has any questions, they can feel free to call me or email me.
Travis, got 3 questions here. This one comes from Sharon. She goes, do you have any recommendations as to where you can get robust and compliant written program templates that hold water with OSHA?
Yeah, there's a lot of different places that you can do that, but if she can email me, I'd be glad to send her a couple of referral sources on that.
Okay, Sharon, if you can send him an email, you'll get what you need there. I got another question here from Mark Berman. He says, a non-job incident like a heart attack while at work, is this a reportable incident?
Well, OSHA likes for you to report heart attacks that occur at the workplace. Mm-hmm. But if we can show that it had nothing to do with the workplace and document that, like we just had one where a guy showed up and he was complaining of chest pains before he got there. And then he just had a heart attack about 15 minutes in. If you have those sort of circumstances, then you just document that and then you put in there why you didn't report it. Because you don't, with reporting and recording OSHA and injuries and illnesses, you just don't want to ignore the obligation. So you want to make a memo to the file and say, we had this happen, this is why we didn't report it, this is why we didn't record it. But if we can show it was not work related, no heat issues, no strain issues, no stress issues, then that you're okay with not reporting it or not recording it. But you got to take it at a case-by-case basis and make sure you document it.
And one last question that's popped in, do you have to have written programs for every facility you operate, even if they have less than 10 EEs on the site?
Yeah, it just depends on what state you're in, but generally you don't have to have one for every location. You can have one safety program that covers all of your locations. California has a few other rules, probably not going to be implemented with less than 10, but you don't have to have separate safety programs for each site unless there's something specific about that site where it has a unique program. And frankly, there's not a lot of requirements, especially for small employers, to have any written safety program. Obviously, it's something that's recommended. But with respect to specific locations, no, I'm not aware of any obligation to do that.
Okay, another question just popped in. This came from Frank. Does the OSHA inspector who shows up on site have to notify management he or she is there? Work at a large facility, can they just enter any door and possibly see a violation?
Yes, they can. They have to make sure that when they show up, they have to let management know that they're there, at least the on-site management. Because if they start doing an OSHA inspection and they don't do an opening conference and notification to you, the management, then everything that they do, we're going to get thrown out. And that's a due process issue. We've had that come up before where they didn't do an opening conference with the management. They cited us for it and we said, sorry, and they were vacated.
Okay, we're running a little short on time. I got one last question here. DeAnthony wants to know, does a hospitalization regarding a service tech from an LOTO violation have to be reported?
From a service tech, from a lockout tagout violation, hospitalization that occurred during work, yeah, that if it's a hospitalization, a lockout tagout violation, you've got to report that. Unless there's some sort of intentional act like a suicide or something like that, that's a reportable.
Okay, great, fantastic. To all of you out there, if you have other questions, obviously you can see Travis's email on the screen here, so feel free to reach out if you've got further questions. But having said that, thank you very much, Travis. This was great information, and I hope everybody out there enjoyed and got some good benefit out of attending today. So once again, Travis, thank you all very much. And to everybody else out there, again, I'd like to invite you to attend one of our upcoming Engage evaluation programs. You should have received an email with an invitation about that. Our goal really is to help transportation fleets achieve greater operating revenues, improve driver retention rates, attain better CSA scores, and improve communication across your company. So if you have interest, please get in touch with us. So thanks everybody for attending today. Travis, again, thank you very much. and we hope to see you on our next webinar program. Thank you.
All right. Thank you all. Thank you. Bye-bye.